So we are here at a briefing for an act ensuring access to addiction services, or what we all fondly call the Section 35 bill, named after the law, the statute that covers addiction services and how we treat folks who are coming before the courts for a substance use disorder. So we've been working, as I said, we've been working on this for many years. And we we are here today because we are hell-bent on ensuring that we stop treating people with a substance use disorder as criminals and instead treat them as people who need care in our healthcare system. We believe this bill plays an incredibly important role on meeting that goal. I want to give you just a little background. Massachusetts is the only state in the country that allows judges to send civilly committed individuals with an alcohol addiction or a substance use disorder to prison instead of to an appropriate healthcare facility. I'd like to repeat that. We are the only state in the country that allows a person with a substance use disorder or alcohol addiction to be sent to a prison rather than to a healthcare facility. And as we know, and as we've learned over and over again, addiction is not a crime. It is a healthcare issue. Many people spend time in correctional facilities for Section 35 civil commitments, and we believe that this is absolutely not right and, in fact, immoral. It's not a setting where someone gets care. So we have made progress in recent years. We do not allow women to be sent to be incarcerated for a civil commitment or a substance use disorder. And in fact, it has been incredibly successful, those programs. And now what we want to do is extend it to men. This bill specifically requires that all civilly committed people with substance use disorder be treated in facilities that are administered by the Department of Public Health or the Department of Mental Health, and not correctional facilities. It also, and most importantly, creates a mechanism to ensure that there's enough capacity across the state, not just in Greater Boston, to actually provide evidence-based treatment to folks. I will stop here because Representative Balzer will share a little more about the bill as well. But I just want to emphasize how important it will be to pay attention to the panel we have with us and how this bill will improve lives of some of our most vulnerable citizens and residents. This panel has a deep understanding of the current system, either because they've had a loved one in the system or they work to help those in the community and those who need treatment. I thank the panel members for taking the time to be with us today and look forward to continuing work on getting this very, very important bill passed. I really appreciate you all coming to this briefing, and I'll turn it over to Rep. Balzer.
Thank you, Senator Friedman. Thank you for co-hosting this briefing today, but also thank you for your leadership on all things mental illness and addiction, and your partnership on this top agenda for both of us, which is to decriminalize addiction and mental illness. And just to somewhat repeat, but maybe give a slightly additional or complementary slant, Section 35 is that law in Massachusetts that allows a court to send somebody who is at serious risk of harm to themselves or to someone else because they have a very serious addiction. And while other states also have civil commitment laws, as the senator said, we are the only state that the civil commitment law explicitly says if the public health beds are full, you can send these folks to a prison program. So just imagine if someone had heart disease and they found out that the cardiac units across the state were full, it'd be like we'd say, okay, let's send them to the cardiac unit in the prison. Because as was stated and can't be said often enough, addiction is an illness and not a crime. And so we are sending men because, as was mentioned, the legislature prohibited sending women. Thus, by the way, putting gender discrimination into our laws, which is unfortunate for its own reason. We have an Equal Rights Amendment that says there should be no discrimination by virtue of sex. But currently, men who are suffering from the serious illness, when the beds are full, are sent to prison programs. And just so you know, the beds are always full. There are a little more than 200 beds for those in public health and mental health programs, and more than 300 in criminal justice settings. And so the men are inevitably sent off to the prison program. We're spending a lot of money, $22 million in the most recent budget, whereas public health programs would actually be self-funded by health insurance plans. So the senator and I are hosting this today really to educate our colleagues in the legislature and their very important staff members on the importance of these bills, and ask, after hearing from a range of points of view from our panel, we'll be asking you, we hope that you will support this as it goes forward this session. I want to now turn the microphone over to our friend and partner, Danna Mauch, who is the president and CEO of the Mass Association for Mental Health. She is a former director of the Rhode Island Mental Health Department, and also a former assistant commissioner for the state Massachusetts Department of Mental Health, where she oversaw forensic programs as well as mental health and addiction programs. And Danna, would you take over?
Thank you very much, Senator and Representative, for your leadership on advancing awareness and the importance of treatment, not incarceration, for people who have behavioral health conditions, and for being very specific in your legislation about the importance of delivering evidence-based care in therapeutic settings. Your bills amend Chapter 123, Section 35, and they're directed to critically needed reforms in how we in Massachusetts provide that care, as both the senator and the representative said. So we're here today to discuss the clinical policy and legal considerations of a vital healthcare service that's needed by people who live with substance use conditions and who've been deemed to be at serious risk to themselves or others because of that condition. For these people who, by the way, are our friends and our family members and our coworkers, our peers, our patients, our clients, however those of you in this room might refer to them. They are, for me, family members and friends and colleagues who live with these conditions. And when I think shortage or no shortage of beds in the Commonwealth, that those people, those family, friends, and colleagues would be at risk of being incarcerated to be treated, it deeply concerns me. And when I see, for those people in our role at the Massachusetts Association for Mental Health, for whom we advocate as our stakeholders, when I see the effects, as I do, talking to them, talking to their family members, talking to their community service providers, I'm deeply concerned and therefore deeply grateful to everybody here today for taking this action. And as the representative said, men, and the senator, men are at risk here because we have a law that allows their incarceration. We have a long history of litigation, starting with women at Framingham Prison who were confined at Framingham because of substance use conditions and told they were being deprived of their liberty in exchange for treatment, got no treatment. And so it's that earlier action on behalf of women at Framingham that really did influence taking affirmative steps to be sure that women were not sent to carceral facilities. But we now need to do that for men. we look forward to hearing from panelists today, and I'm going to introduce them in a minute to you. But I want to do a quick recap here. We've talked about the legislation in the House bill. It's very directly going at the issue that men who are civilly committed under Section 35 will be treated in a healthcare facility, not a correctional facility. Very simple, very straightforward. In the Senate bill, it moves to redefine the use of the term facility in Section 35 to make clear that a facility is a public or private facility that provides care and treatment for a person with an alcohol or substance use disorder, and that for purposes of this revised section, facility shall not include any jail or correctional facility or any other facility funded, controlled, or administered by a sheriff or the Executive Office of Public Safety, or any agency under the jurisdiction of the Executive Office of Public Safety. It also specifies that the Secretary of the Executive Office, Health and Human Services, shall ensure an adequate supply of beds in therapeutic settings, and that, by the way, such facilities, including secure treatment facilities, shall be geographically distributed throughout the Commonwealth to provide access to treatment for all regions in Massachusetts. So these are important details of the legislation and why so many of you I know who are here today are supporting this. Unlike, by the way, Section 35 is part of something called Chapter 123 in Massachusetts, which is a host of provisions relating to the civil and forensic commitment of individuals with behavioral health conditions. Section 12, which is one of many sections relating to the commitment of people with mental health conditions, does specify that people have to be committed to a hospital. So we're really asking for the same treatment for people who are committed because of a substance use condition as accrues to people who have mental health conditions. And by the way, this has been an issue that's been grappled with in the law for a long time. Addiction was a crime in federal and state statutes until 1962 in a case called Robinson versus California, where it was basically found unconstitutional to consider addiction a crime. So here we are. What's the difference between, somebody can do the math, 1962 to 2023? It's 61 years, right? Okay, my math is still intact. Anyway, here we are still addressing this issue in the Commonwealth. And as the senator said, we're the only state in the nation that is still incarcerating people. So when Section 35 was written, actually back in 1970, its reference to prisons as a place of commitment was out of sync with federal law and frankly out of sync with practice of treating people with behavioral health conditions. The underpinnings of modern civil commitment were shaped by a case in 1966 called Rouse v. Cameron, and Chief Judge David Bazelon, after whom the Bazelon Center for Mental Health Law was named. And I want to note that Mary Giliberti is with us today, who's a former federal court clerk and also was a fellow at the Bazelon Center years ago. That law said that because the purpose of civil commitment and involuntary hospitalization is treatment, not punishment, the hospital has a duty to, hospital has a duty to furnish adequate treatment, and the patient has a legal right to receive that treatment in a therapeutic setting. Other cases, one a lot of people refer to, O'Connor versus Donaldson in 1975, says that individuals, once not posing a serious risk of danger to themselves or others and capable of living outside of an institution, have the right to treatment in a community facility. And we have community facilities available. So we're really narrowing in on this issue of where people are committed. And I just can't underscore enough, history aside, that the issue here is if one loses their liberty due to a mental health or substance use condition, one has the right to treatment, and not just treatment anywhere, treatment in a therapeutic environment. So the time is now for Massachusetts, residents to benefit from these rights and the promises of the legislation that the senator and the representative have filed. So I'd like to introduce our panel and bring them up here if they could join me. Joe Riggs of the Massachusetts Organization of Addiction and Recovery, MOAR, is with us today. Bonnie Nuendell, a family member of a MASAC inmate, is here. You'll see Bonnie on the screen. She's joining us virtually. And Deb Goldfarb, who's a clinical treatment professional from Boston Medical Center, is here. And last but not least, Bonnie Tenerello, who's a senior staff attorney at Prisoner Legal Services. So do you want to come up? Introduce a bit about yourselves to the audience. Thank you.
Thank you, Dr. Mauch. Thank you, Representative Balzer and Senator Friedman. Thank you for the bills, H1966 and Senate Bill 1247. And I appreciate your leadership on this important legislation. It's my pleasure to be here. I'm here, thank MOAR, Massachusetts Organization for Addiction Recovery, for inviting me to speak on their behalf in strong support of this legislation. MOAR is I've been a volunteer for MOAR, and they've been a fabulous organization in the community, helping countless lives through their events. I've seen recovery homes, sober homes, recovery community centers all coming to our events and learning more about recovery and supports that they offer in the community and what they've done just to help so many people. I'm also here to speak as somebody and lived experience who has experienced substance use disorder and all the challenges that it faces. And it's an honor to speak, to share with you a little bit about me so that we can help others. It's about those that are still suffering. Each person is struggling with substance use disorder. I know what that pain feels like. There's a little bit of me in each of them. And while I found the ability to overcome those issues, it's my hope that others will establish policies that will help them and help more people in better society. My story, as long as I have substance use disorder, I entered recovery. I'm in long-term recovery, and since then I've been able to finish my undergrad degree, graduate degree, earn my PhD, did my postdoc for a few years at Harvard Medical School, and then go on to be a scientist at Massachusetts General Hospital. I work out Department of Neurology, work on Huntington's disease, and I share that with you. One, to establish, the objective nature I have as a scientist. In science, we search for the truth, and humbly, and that's what I hope that the policymakers and legislators do today, that we each dig deep into a truth that we see that we seek to serve best for society and those that are suffering, and to provide hope for those that are still suffering, to know that recovery is real and that each and every one of us can find new opportunities for the hopes and dreams that we have, no matter how bad things may have gotten or seemed. I'm living recovery, and recovery is available for all. What we do to help persons find recovery matters. While I remember, while we can get the drugs out of my body, I don't get the memories out of my mind. And when we put things into a criminal setting or Department of Corrections settings, that sticks with the person, and it's impactful and it's impressionable. And there's better ways to approach it. And I feel like we're sitting in a fork in the road where we have a choice. Do we want to keep going down Department of Corrections that is good at what they do? Or do we want to go down Department of Public Health that is good at what they do? And which one seems better to serve somebody who's having substance use disorder? I know the feelings of stigma and shame, and I don't want anybody else to have to feel those things. And I know the feeling of connectedness, and connectedness matters. And I've just never known Department of Corrections to help somebody feel connected with society. I've only known it to help invoke shame and stigma and pain, and those aren't helpful for somebody who's trying to get help. And I think and that's the other part of my story is that I want each and every one to know that we do thrive in recovery. We do wonderful and awesome things given the support and help that we need. And I'm living proof. Others are living proof. I'm not unique. I'm one of many. And but when given the chance, people in recovery do awesome and wonderful things for society. Service is a very big component of people in recovery's approach to their new life. I'm also a parent, I'm a parent of a high school age son, and I think about the future I want for him, and I wonder. We throw stats out, but over 7 million kids have drank alcohol between 12 and 20 years of age in the last month. And over 60% of seniors have abused alcohol. By 12, have abused alcohol. So if my child ends up being one of those many millions of adolescents that have used a substance and ends up needing help one day, and I've got to civilly commit my child, I hope that never happens. I would be scared to civilly commit my child into a Department of Corrections knowing what I've experienced. I wouldn't want to do it. But if I knew that I'd get him help through the Department of Public Health, that's something that I could consider. And I want the future. We have a chance to make changes for people now and in the years ahead. And I hope we do make those changes. That's why I'm a strong supporter of this legislation. That's why MOAR is in strong support of this legislation. And that's why I hope the entire community will get in support of this legislation. Thank you.
I couldn't hear anybody. Did you want me
Bonnie,
to?
can you
Yes,
hear me?
I can hear you now, yes.
All right, I want to welcome Bonnie Nuendell, who is the mother of a family member who's been at NASAC to speak with us today. And take your time, Bonnie, and we look forward to hearing from you.
Thank you. Thank you very much to Representative Balzer and Senator Friedman for your ongoing efforts to change this tragic law that allows incarceration of addicted persons. My name is Bonnie Nuendell, and I'm from Eastham, Mass. I'm the mother of Andrew Nuendell. I have petitioned to commit my son 2 times under Section 35. I petitioned for his commitment in March of 2021 and November of 2022 out of the Orleans District Court in Barnstable County. Andrew was diagnosed at 21. He's 49 years old now with bipolar disorder. He has disability. He has benefits from disability insurance. He was raised in Schenectady, New York, and when he was diagnosed at 21, he was given a whole range of services there, which have stayed with him through his transfer back to, we moved him out here to be closer to us because of ongoing issues. So back there, he was given a Section 8 assistance with an apartment, a job coach, a counselor, a psychiatrist, and he managed quite well. He came out here And in 2016 and did fairly well. I committed him the first time in 2021 out of concern for his health due to his mental illness and alcohol misuse and therefore erratic behavior. I had called the police as Andrew barricaded himself inside his apartment, blocking the police out. The police said that they could not commit him to treatment themselves and told me about Section 35. I did proceed to the courthouse. I was given assistance and coaching about how to proceed, and the judge ruled that he would be he would be removed from the home forcibly, and he was taken to Stony Brook Treatment Center in Hampden County and then transferred to the Mass Addiction Treatment Center at High Point. The facility looked like a jail, but it wasn't as bad as the second commitment at Massachusetts Alcohol and Substance Abuse Center. When he was committed there, his alcohol use and mental illness was out of control. While he was in MASAC, he would call me distressed and told me how horrible it was. He told me about mistreatment from staff and how they assaulted him. I remember seeing the bruises on him when he came home. My son has told me that if I sectioned him again, he would never speak to me again. That's how horrible the experience was for him. There's regret in my decision, but with regret, you wish you could have done something differently. And I didn't feel there was anything else I could do at the time. I never wanted to section him. I had to, there was no other option available. However, I didn't know I would be sending him to jail. I started to think to myself, what have I done? And how did he end up here? He has a mental illness. How did he end up in a place like this? When I committed him the second time, the judge said something to the effect of, I'm sorry, I couldn't get him in where I wanted. This was my first flag that something about where he was going was different. I didn't want to accept that something bad was happening when he went to MASAC. I didn't want to feel responsible for this experience happening to my son, and I was in disbelief that there was nothing for his needs aside from this jail. During his incarceration, which is what I call it, my state of mind was a mess. Everything was bad, and I could not function normally. Our family didn't put up a Christmas tree or celebrate that year. It wiped out everything in our lives to know he was living in these conditions because he was mentally ill. I would not commit him again because I've heard the distress. I've seen the bruises, and I don't want that to happen to my son. However, I can't say what I would have done instead. There are no options. I hope the work on this bill will lead to other choices for people like my son. Thank you.
Bonnie, for sharing that with us and inspiration that brings. Just before I introduce that Goldfarb, I'd like to recognize Director D. Howard of Substance Massachusetts. Thank you. So Deb Goldfarb, would you like to introduce yourselves?
Yeah. Sure. So I'm Deb Goldfarb. I'm a social worker. I'm an advocate. I'm an educator. I'm the director of behavioral health within population health services at Boston Medical Center. And there I work closely with the Graken Center for Addiction on issues related to criminalization of addiction. Both Boston Medical Center and Graken support this piece of legislation. I also teach at Boston University School of Social Work, and I co-lead the National Association of Social Workers Mass Chapter Criminal Justice Committee, and NASW has been a long supporter of this legislation as well. As we've heard, we know that substance use is associated with increased risk of morbidity and mortality, and therefore public health officials, healthcare professionals, loved ones, we try to seek policy remedies to reduce those burdens. But as we heard, it's really counterintuitive to uphold policy that violates individual human rights and places them in counter-therapeutic settings. We should be looking to the research and experts to guide our intervention, and both are saying stop using correctional facilities for treatment. There's clear evidence showing the poor treatment outcomes for those in correctional environments. Throughout my career, I've worked with hundreds of individuals negatively impacted by our current Section 35 system. I also think I know what good patient-centered behavioral health treatment looks like, and correctional facilities holding individuals on 35s are not providing that. Successful recovery from a substance use disorder requires lots of things, but also addressing shame, stigma, trauma, and underlying mental health disorders. Shame can be one of the most significant triggers for use and relapse of substances. I worked at MCI Framingham as a clinician for about 3 years, and the first year, women still came to Framingham on Section 35s. I recall meeting with many women when they arrived at the prison on a 35, looking at them, trying to evaluate them and support them through cell bars. They were physically sick, defeated, and wrapped in shame. Being sent to prison instead of a healthcare environment worsened this shame and impacted their ability to engage in recovery. Overcoming stigma is another large barrier in achieving recovery. Those in recovery often internalize the stigma around their drug use behaviors, causing an immense emotional barrier. Using correctional settings for treatment perpetuates stigma as it continues to send messaging to those trying to find recovery that they have morally failed and that society views them as criminals. I remember working with individuals at Framingham who were scared to call their loved ones and their employers important parts of their recovery from Framingham when they're there on a 35 for fear that their loved ones or their employers would assume, or DCF, anyone in their life, would assume that they committed a crime instead of receiving medical care. Research shows that folks with substance use disorders have high prevalence of trauma. That's even higher in populations impacted by homelessness and mental illness. The correctional environment can trigger many trauma-related symptoms because of the physical environment, the lack of daylight in windows, the presence of uniformed officers, having to talk to your clinician through prison bars instead of in an office or treatment space. As a clinician, I felt it was impossible to provide ethical, trauma-informed care in a correctional setting. We cannot expect someone to heal from their trauma in an environment that is actively traumatizing them. Without addressing trauma, recovery from substance use can be near impossible. We also know that mental illness is deeply connected with substance use disorders. Many individuals with addiction have untreated mental illness, and addressing this illness is a key component of recovery. There's significant evidence showing correctional environments are harmful to one's mental health, exacerbating symptoms given the isolation, control, and punitive nature of the environment. Correctional environments induce anxiety, deepen depression, and can lead to significant mental health crises, including suicidal thinking. The correctional environment doesn't allow certain clinical modalities to be carried out effectively. I remember trying to run countless groups where correctional officers were present, which any therapist or clinician would know that completely changes the therapeutic environment. So all of that has led to many of the adverse events we have seen occur in these facilities for individuals with severe and persistent mental illness. Taking jail and prison units and turning them into treatment centers does not change the harsh and punitive environment. In a correctional setting, which MASAC and Stony Brook are, security will always take precedent over recovery. Correctional facilities are not the answer to addiction treatment. It's common for opponents of this bill to talk about bed availability. We, the addiction community here in Massachusetts, pride ourselves on providing innovative clinical programming that is patient-centered and evidence-based. Our current Section 35 process is neither. We can do better, and those living with a substance use disorder and their loved ones deserve better. A simple step to do better is to stop sending men to correctional facilities to receive care and instead send them to DMH and DPH facilities, which we do for women today. Just want to also thank the legislators, prisoner legal services, and for folks for sharing their personal stories up here.
Thank you, Danna, and thank you so much to Representative Balzer and Senator Friedman for your consistent leadership over years on this issue. I hope this is the year that things change. I from what you've heard, I hope it's clear that using corrections to hold people for treatment of alcohol and substance use disorder is harmful and counterproductive. I'm going to talk a little bit briefly, and Danna started to talk about this, about why it's unlawful for the state to keep channeling funds meant for treatment into correctional budgets. Civil commitment, the first thing I want to say is that it violates the Americans with Disabilities Act. This is a vestige of a time when people with alcohol and substance use disorder, as Danna was alluding to, we're seen as morally weak, not worthy of care, and less worthy than people with other diseases of medical treatment. We don't treat any other, as Danna said, with Section 12 and other forms of mental illness. We would not consider sending people to prison to a correctional facility of any sort, except under criminal charges. And the ADA was enacted precisely to end this kind of attitude towards disabilities, including addiction. The stigma that everyone on this panel has talked about and the shame, this happens the moment you walk through a door, the moment you are told you belong in a facility operated by the Department of Corrections or by any other correctional agency. That's when the harm is done, no matter what happens inside. That's the message and it's not just you as a patient, that's the message that goes out to the community. That's what the community is being told. These people belong in a correctional setting. As long as we continue that's the message we send by continuing to put our money there. As I think everyone from Senator Friedman and Representative Balzer have acknowledged, it's gender discrimination. I don't think I need to say a lot about that. It took a lot of work to end this treatment for women, and the Baker administration was very proud of this at the time, and rightly trumpeted it as an achievement. Well, we need to be doing this for men too. The state claims it's a state without stigma, still doing it to the women. I don't think I need to say a lot more about the gender discrimination. And I mean, there's a lot more to say about the law in each of these areas, but I don't think, I'm not going to go into depth here today. If people have questions, I'd be glad to talk about that. And finally, it violates constitutional due process. When we take away people's liberty, as we do with any form of civil commitment, we have to do it in a way that's narrowly tailored to serve a compelling interest. And it has to be the least restrictive means available to vindicate that compelling interest. Well, we're not doing that when we're sending people to correctional facilities. That is not a narrowly tailored or the least restrictive means available to offer treatment. And as Danna said earlier, this undermines the very purpose of the statute, which is treatment, and by imposing this unjustified deprivation of liberty. So, in addition to ending all the harms that you've heard about in such a compelling fashion, I think it's time to pass this law to end really an unlawful status quo.
Anyway, thank you for coming, but also thank you to some of the staff members coming. Danna, you can take a question.
So, thank you, Representative. So if you have questions, for the panelists, yes, please. Would you identify yourself? Yeah, thank you. Stay at K9 field. Is it for the microphone?
Yes.
This isn't really a question, but I wanted to share my story, if that might be okay. Thank you. Thank you, panelists. Thank you, everybody, for hosting this. I hope I don't get too emotional as I share the story. But my son was struggling with substance use disorder in 2018, and he overdosed and was Narcaned. A good friend of mine said to me, "You should section him. You should section him." And I thought a lot about it because I wanted him to stay alive. And I put a lot of thought into it, but my reservations about how effective forced treatment is gave me a lot of pause, but especially the fact that I knew it was highly likely that he would be sent to MASAC, a correction facility, where he would not be offered Suboxone or some of the gold standards of treatment. 3 weeks after that conversation, my son overdosed and died. And if Section 35, if I knew he could go to a truly therapeutic facility, I might have made a different decision. I urge all of you to think about this, and thank you for setting this up, and thank you for the opportunity to say something. Thank you. Thank you. I'm looking at the cameras for sharing the story about what it's like now. But I was wondering, how different are things at MASAC now that WellPath is there and they're claiming it's more therapeutic? And I wanted to acknowledge Brian's sister, Jocelyn, who's here with me.
I see Representative Scarsdale on the screen. Welcome, Representative.
I think largely in response to this legislation pending for so long, and also to pending litigation, the Section 35 correctional facilities have been switched up a little bit to look a little kinder and gentler. In the case of, to answer your question directly, in the case of MASAC, they pulled the corrections officers out to the perimeter and have staff that are no longer called corrections officers inside. Superintendent is still Department of Correction. Department of Correction rules and policies and culture still control, and WellPath. Now, I am not speaking here about the way in which it administers MASAC specifically, but it is a correctional healthcare company with deeply ingrained, with all that carries, but that's not a central issue here, but they're certainly a lot problematic, and they've been sued in many contexts. Again, I'm not addressing their care at MASAC when I say that. But I certainly I don't want to say it's the same, but I can tell you, having interviewed dozens of people over the years, the correctional culture still pervades, and they still use isolation.
Could I just add to that about the isolation? Our son, in the 28 days he was in, was put in isolation 3 times. I've read since then that is, for someone with a bipolar illness, high potential for suicidal attempts. So I felt that was, not treating him as a person with a disability, but instead just getting him out of the way for their convenience. So I just wanted to address that.
Yeah, and I just want to say, and I think it's a great question because I think the answer is it doesn't matter,
Yes.
right? I mean, there is supposedly a very good program in, I think, Hamden County, I can't, through the sheriff's office. It doesn't matter. You cannot commingle the corrections side of the world with the treatment side of the world. And I think especially our Department of Corrections and many of our houses corrections, but not all, have proven that over and over again. But just to even entertain the idea that it could happen, that those two could go together is a falsehood. It makes people feel better. It feels like we're doing something, but it absolutely is an untruth. So whether they're good at WellPath or not, doesn't matter. WellPath can do their job in a facility that isn't a Department of Corrections if they're really good at it, right? We're not stopping that. In fact, we're saying go out there and get more facilities, but there's just under no circumstances will it work to have these two things commingle. So, it's a great question because you get to say, doesn't matter, right?
Representative Scarsdale want to?
Yes,
just a minute. Or is she just on the screen? Can't.
Representative, did you want to speak?
Just to thank everyone for their eloquence and sharing personal stories about such a traumatic and heartfelt events. And I think, like everyone here, I really hope we can get the job done this year and take care of this situation.
Yeah. Hi, everyone. My name's Alice Bookman. I'm an emergency medicine physician at Brigham and Women's and Faulkner Hospital. And I just wanted to offer my viewpoint as somebody who is approached about doing this a fair amount. When I've basically been working in Massachusetts for the past, over a decade, and have been part of sectioning many people. And it wasn't until fairly late in my career that I realized what actually happened to the people that we sectioned. And with that knowledge, and I myself have felt that it is a violation of my Hippocratic oath to do no harm, to put men on a Section 35. And that feeling has really spread to, I would say, most of my colleagues that I work with. And what is so tragic is that we have so many people coming to us asking for help in the emergency department. And a lot of the times what we're able to give them is a list to call. And it just seems to have, on the one hand, this amount of funding going to something that I do not feel as a physician I can, in good faith, actually do to my patients as really the only option, and then no options really for the folks who come to me desperately seeking help. So I really appreciate all the leadership around this, and thank you.
A little bit about where this bill has gone. Last session, it won the support of both the Joint Committee on Mental Health and Substance Use and also the Committee on Healthcare Financing. So it has a lot of legislative support. We're hoping that this session, it will, again, of course, get the approval of those two committees, but then move on to both chambers and get it to our new governor's desk. And I just wanted to let you know, bill numbers are House 1966 and Senate 1247. It is not too late for legislators to sign on to be co-sponsors as one way of showing their support, as well as weighing in as the bill starts going through the committee process. And I just want to say we had wonderful conversations with the Department of Public Health, with the new administration, with the new Attorney General. There's lots of reason, and this is so important for people to just hear the stories, because I think one of the challenges we faced was people just didn't know a lot about this and didn't really know that Massachusetts was sending very sick people to criminal facilities rather than to healthcare facilities. So I just wanted to close on that note. I didn't know if I wanted to know if you wanted to close or.
I would thank everyone on behalf of our leaders, Representative Balzer and Senator Friedman. I think we've heard today the importance of supporting these measures, and for those who are so inclined to have the resources and the time and energy, let's double down on our efforts here to get further support for the bill and see what we can do to get it passed this year and onto the desk of the governor. Thank you.
Thanks.